An injured person doesn't have to prove their case beyond a reasonable doubt. And that surprises a lot of people. I'm New York personal injury lawyer Brian O'Connor. And this is one of those courtroom rules that sounds technical, but it can decide the entire case. Now, beyond a reasonable doubt is the standard that most people hear about in criminal cases. You see it talked about in TV dramas and in movies, but in a civil injury trial, the standard is different. It's called a preponderance of the evidence. Now, in plain English, it means more likely than not it's true. So think of the scales of justice. The jury doesn't have to be certain, and the injured person doesn't have to prove the case by 75%. They don't have to remove every possible doubt, but they do have to tip the scale. They still have to prove that the defendant was negligent, and they still have to prove that the negligence caused the injury, and that is by a preponderance of the evidence, more likely than not. And they still have to prove that the damages existed as a result of the injury. Now, the defense doesn't have to prove that the injured person is wrong. The defense can simply say the plaintiff didn't prove it. That's why trials are not about sympathy. They're about evidence, witnesses, photos, medical records, details. That's what moves the scale. But in an injury case, it only needs to move the scale a little bit. If you find courtroom insights like this interesting, follow us for more videos about how the legal system really works and sharing practical legal tips that most people never hear about.